Hello, this is Darby and Chelsea from the Global Human Rights Clinic at the University of Chicago Law School. Today, we will be talking about economic and social rights as viewed through the International Human Rights Law Framework. Economic and social rights are guaranteed in the International Covenant on Economic, Social, and Cultural Rights, or ICESCR for short. ICESCR was signed in 1966, created by General Assembly Resolution 2200A, and came into force in 1976. It guarantees the rights to education, health, and much more. We will provide an overview of the Convention, the rights guaranteed, and the extent to which the United States is bound by these provisions. ICESCR itself did not create a treaty body. Rather, it placed administration and enforcement rights in the Economic and Social Council. In 1985, this council, the ICESCR, created a treaty body, the Committee on Economic, Social, and Cultural Rights, or ICESCR. Article 2 of ICESCR provides for the obligations of states under the Covenant, requiring states to take steps for the progressive realization of the Covenant, using the maximum amount of resources available and using all appropriate means. ICESCR provides guidance on the meaning of this article. First, progressive realization means that states must move as expeditiously and effectively as possible towards the goal of fulfilling these rights. There is an understanding, however, that there may be limitations in a state's available resources that may actively prevent that state from fulfilling its full obligations under the Covenant. These states must take steps to the full extent to which they are able, using the maximum resources available. Second, if a state is unable to provide all rights to their full extent, they must provide minimum essential levels of each right. This means that if a significant number of individuals are deprived of essential foodstuffs, primary care, basic shelter and housing, or of the most basic forms of education, then the state would be failing to discharge its obligations under the Covenant. But again, resource constraints of a given state may be taken into account. A state must show that every effort has been made to use all resources that are at its disposal in an effort to satisfy, as a matter of priority, those minimum obligations. Article 3 prohibits discrimination on the basis of sex. Article 4 permits states to impose limitations on these rights when three conditions are met. First, the limitation must be imposed by law. Second, the limitation must be compatible with the purposes of the Covenant. Third, it must be for the purpose of promoting the general welfare in a democratic society. Notably, and unlike the ICCPR, ICESCR precludes derogations in times of emergency. Lastly, under the terms of ICESCR, state parties are to submit regular reports on their progress to ICESCR, not ICESCR, which will provide concluding observations and recommendations. In an optional protocol established in 2008, two additional enforcement mechanisms were created: the Interstate Complaint Mechanism and the Individual Petition Mechanism. The Interstate Complaint Mechanism allows a committee to investigate into grave or systemic violations of the Covenant, other than the violation of self-determination, with the consideration to the reasonableness of steps taken by the state party to fulfill the rights or remedy the harm. The Individual Petition Mechanism permits individuals or a group to bring a claim on behalf of a victim for violation of any right of the Covenant under the following conditions. First, the claim cannot be currently under examination in another international forum, and second, there must be domestic exhaustion. Now, I'll pass it off to Chelsea to talk more about the specific rights guaranteed by ICESCR.
Thanks, Darby. So, ICESCR notes a number of rights that state parties must provide and protect. Among the rights included in this covenant are the right to self-determination of all peoples in Article 1, Articles 6, 7, 8, and 10 contain various employment-related rights, such as the right to work and earn a living freely and voluntarily, the right to form and join a union and go on strike, the right to just and favorable working conditions and remuneration, including a safe and healthy working environment, equal opportunity and employment positions, reasonable work hours and time for leisure, fair wages that provide a decent living, and equal pay for equal work. Article 10 provides some additional employment-related rights that are specifically related to the protection of families, such as the right for mothers to have time off before and after childbirth, and prohibitions on child labor. Moving on, the right to Social Security and social insurance are found in Article 9. Article 11 provides for the attainment of a decent standard of living, which includes adequate food, clothing, and housing, as well as the continuous improvement of living conditions. Article 12 provides for the right to the highest attainable standard of physical and mental health. Lastly, Article 13 contains the rights to education, which not only provides for primary education that is free and compulsory, but also secondary and higher education that is equally accessible to all. Together, these are the rights provided and protected by ICESCR. As the preamble of the covenant notes, these rights are inherent in the dignity of the human person, and they provide for the ideal of a free human being, which can only be achieved if conditions are created whereby everyone may enjoy his economic, social, and cultural rights in addition to his civil and political rights.
ICESCR Commentary 14 provides insight into the requirements and obligations of states under ICESCR Article 12, the right to the highest attainable standard of health. Article 12 begins by stating that the states parties to the present covenant recognize the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. ICESCR explains that the highest attainable standard requires a right to the enjoyment of various facilities, goods, services, and conditions necessary for that realization. ICESCR notes that this highest attainable standard is not limited to the healthcare concerns that were present when enacted, but extends to new healthcare concerns as they arise in modern contexts. It identifies 4 elements in this standard. First is availability, or the requirement that functioning public healthcare facilities, goods and services, and programs must be available in sufficient quantities. These facilities, goods, and services include, but are not limited to, drinking water, sanitation facilities, hospitals, clinics and other health-related buildings, trained medical and professional personnel with domestically competitive salaries, and essential drugs, as defined by the World Health Organization. Second is accessibility. The facilities and services must be accessible to anyone without discrimination on any prohibited grounds. This includes physical accessibility. The facilities must be in safe physical reach for all sections of the population, especially vulnerable or marginalized groups. Economic accessibility. The services must be affordable for all. This includes the idea that poorer households should not be disproportionately burdened with health expenses as compared to wealthy households. And information accessibility. The right to seek, receive, and impart information and ideas concerning health issues. The third element of the highest attainable standard is acceptability. Health facilities, goods, and services must be respectful of medical ethics and must be culturally appropriate. Additionally, they must be designed to respect confidentiality. The final element is quality. There must be skilled medical personnel, scientifically approved and unexpired drugs and hospital equipment, safe and potable water, and adequate sanitation available. ICESCR Article 12 requires states to take steps to achieve the full realization of the right to health, including those necessary for the reduction of the stillbirth rate and infant mortality and for the healthy development of the child, the improvement of all aspects of environmental and industrial hygiene, the prevention, treatment, and control of epidemic, endemic, occupational, and other diseases, the creation of conditions which would assure to all medical service and medical attention in the event of sickness. However, ICESCR makes clear that these are not the only rights implicated in Article 12, nor are the enumerations to be narrowly read. For example, ICESCR states that a state's obligations extend to the provision of access to safe and potable water and adequate sanitation, adequate supply of safe food, nutrition, and housing, healthy occupational and environmental conditions, access to health-related education and information, and includes the freedom for citizens to participate in their own health-related decision-making. This is supported by the legislative history demonstrating that these considerations were present when the covenant was created. ICESCR further elaborates on the rights enumerated in ICESCR Article 12. Some examples are the right to prevention and education programs for STDs and the promotion of good health, such as environmental safety, education, economic development, and gender equality, the right to the creation of a system of urgent medical care in cases of accidents, epidemics, and similar health hazards, and the provision of disaster relief and humanitarian assistance in emergency situations, and the right to, for both mental and physical health, timely access to basic preventative, curative, rehabilitative health services and health education, regular screening programs, appropriate treatment of relevant diseases, illnesses, injuries, and disabilities. This includes provisions of essential drugs and appropriate mental health treatment and care opportunities. Lastly, ICESCR provides several additional state obligations in administering the right to health. Among them are the obligation to respect, protect, and fulfill these rights, along with a related requirement that victims be given sufficient remedies for violations. First, a state must respect the right by providing and recognizing the right to health care. Considerations under this obligation may be the inclusion of all categories of persons in healthcare, including those most vulnerable to exclusion, such as prisoners, detainees, immigrants or migrants, both legal or illegal, and women. Refraining from prohibiting or impeding traditional preventative care, healing practices and medicines from marketing unsafe drugs, and applying coercive medical treatments. Refraining from censoring sexual and reproductive health or withholding or misrepresenting health-related information, including sex education. Finally, states should refrain from unlawfully polluting the air, water, and soil, such as by testing or using nuclear weapons, and should refrain from limiting access to the health services as a punitive measure. Next, states should protect the right to health care from third-party action, which may undermine or interfere with the provision of these rights to certain individuals or groups of people. This obligation requires states to adopt legislation or other measures to ensure equal access to healthcare and health-related services that are provided by third parties. For example, states should take measures to ensure that the privatization of the health sector does not constitute a threat to the availability, accessibility, and acceptability of quality health facilities, goods, and services, to control marketing of medical equipment and medicines by third parties, to ensure that medical practitioners and other health professionals meet appropriate standards of education, skill, and ethical codes of conduct, and to take measures to protect vulnerable or marginalized groups in society like women, children, and the elderly. Finally, states must ensure that they fulfill their obligations, which includes facilitation, provision, and promotion of such rights. This requires the facilitation of positive measures to enable or assist individuals to enjoy their right to health, the provision of a specific right when individuals are unable, for reasons beyond their control, to realize that right themselves, the promotion of a right by creating, maintaining, and restoring the health of populations, the adoption of appropriate legislative, administrative, and budgetary provisions, as well as judicial promotion and other measures necessary for full realization, and the creation of a national health policy for the realization of the right to healthcare, which must ensure provision of healthcare including an immunization program, ensure equal access for all to the underlying detriments of health, such as nutritionally safe food, potable drinking water, basic sanitation, and adequate housing and living conditions. Ensure that the health insurance systems are affordable for all, ensure promotion of medical research and health education, and adopt efforts against environmental and occupational health hazards, including policies to reduce or eliminate pollution in the air, water, soil, and to reduce occupational accidents and disease. ICESCR states that under no circumstances can states justify non-compliance with certain core obligations. These core obligations include non-discrimination, ensuring the right of access to health facilities, goods, and services on a non-discriminatory basis, especially for vulnerable or marginalized groups, no hunger, ensuring access to the minimum essential food, which is nutritionally adequate and safe to ensure freedom from hunger for everyone, basic needs, ensuring access to basic shelter, housing, and sanitation, and an adequate supply of safe and potable water, drugs, providing essential drugs as defined under the WHO, equality, ensuring equitable distribution of all health facilities, goods, and services, and a national health strategy, the adoption and implementation of a national public health strategy that includes marginalized groups. This strategy should identify appropriate right to health indicators and benchmarks in order to monitor national and international levels and states' obligations under Article 12. Other non-core obligations can be limited if the state can show that it has attempted but otherwise cannot fulfill its obligations. Lastly, ICESCR states that any person or group victim of a violation to the right to health should have access to effective judicial or other appropriate remedies at both national and international levels. All victims should be entitled to adequate reparation, which may take the form of restitution, compensation, satisfaction, or guarantees of non-repetition. Back to Chelsea.
Overall, there is widespread acceptance of ICESCR. 171 states have signed and ratified the covenant and are therefore fully bound by its obligations. 4 states have signed without ratifying. This includes the United States, meaning these states are not bound by the terms of the treaty. 22 states have not taken any action. As for the optional protocol, only 26 states have ratified it, while 23 states have signed without ratification. 149 states have taken no action. In terms of U.S. compliance and perspective, it is clear that prevailing attitudes today do not recognize economic, social, and cultural rights. However, this was not always the case. In his 1941 State of the Union address, President Franklin Roosevelt called for improvements in unemployment insurance, old age pensions, and medical care, as well as a better system for obtaining employment. In the president's eyes, the country had already accepted certain economic truths as self-evident, and it was time for Congress to solidify these sentiments with legislation. As Roosevelt noted, necessitous men are not free men, and that meant that individuals needed the right to a job that would earn enough to provide adequate food, clothing, and recreation, the right to adequate protection from the economic fears of old age, sickness, accident, and unemployment, and the right to a good education. While this speech served as inspiration for the drafting and adoption of the Universal Declaration of Human Rights, it came about 30 years before the birth of ICESCR, and unfortunately by this time, sentiment had shifted. Lyndon B. Johnson was the president when ICESCR was drafted and adopted by the UN General Assembly. However, the U.S. did not sign the treaty until 1977 when Carter was president. Carter submitted ICESCR to Congress with a package of reservations and declarations, but Congress refused to give advice or consent to the covenant. Forgotten until 1993, the Secretary of State under the Clinton administration stated its intent to ratify ICESCR, but this never happened. At the same time, the United States took steps to undermine economic, social, and cultural rights. During the Reagan administration, the State Department removed economic and social rights indicators from country reports that were prepared by the State Department, retaining only labor rights indicators such as freedom of assembly, collective bargaining, and the like. In a similar move, at the beginning of the Clinton administration, the bureau preparing these state reports was renamed from the Bureau of Human Rights and Humanitarian Affairs to the Bureau of Democracy, Human Rights, and Labor. These rights tracked the shift in priority and sentiment away from economic and social rights. During George W. Bush's administration, economic and social rights came under direct attack. In speaking at the UN, a US representative stated that even though goods like food, clothing, housing, and education are components of an adequate standard of living, they do not constitute human rights in the full sense of the term. From the United States' perspective, an individual had no legal standing to bring a claim for want of these basic needs. In other words, these economic, social, and cultural rights were non-justiciable. Instead, these rights could be attained through participation in the democratic and political processes. And the US stands its ground on these ideas. Thus, when states are violating human rights, the US will quickly call out violations of civil and political rights, while ignoring violations of economic and social rights. For example, in North Korea, when widespread experiences of hunger, starvation, and denials of medical care occurred, the United States statement to the Human Rights Council focused solely on civil and political rights violations, such as denying freedom of speech, religion, the press. These flippant attitudes are perhaps most apparent in domestic life. In fact, despite the country's wealth, the United States has one of the poorest records of economic and social rights achievements of all high-income countries, as evidenced by its 2010 Universal Periodic Review. More recently, the UN Special Rapporteur on Extreme Poverty and Human Rights warned of greater inequality coming out of recent US tax reform. Philip Alston's graphic depictions of Black Alabama residents living amongst sewers, of poor Virginians with mouthfuls of rotting teeth unable to access dental care, or of American children suffering from diseases like hookworm that are long considered to be eradicated in developed countries, illustrate the United States' widespread failures to fulfill basic economic, social, and cultural rights. The Special Rapporteur wrote, "The U.S. is alone among developed countries in insisting that while human rights are of fundamental importance, they do not include rights that guard against dying of hunger, dying from a lack of access to affordable health care, or growing up in a context of total deprivation." Circling back to the ICESCR itself, these real-life examples of failure to provide economic, social, and cultural rights drive home the point that underlying these rights is human dignity and the very ideal of human freedom. They deserve to be respected.